the intended replacement is male. In our view, our rights under Article 27 of the Constitution of Kenya will be violated. 6, that the impending impeachment is unfair, unreasonable, and unconstitutional. This court on the 12th February 2019, following the petitioner's motion dated 4th February, temporarily suspended the impeachment motion pending the determination of the said application. However, that notwithstanding, the County Assembly of Tharaka Nithi went ahead and removed the petitioner as Deputy Speaker. The petitioner filed another application dated 13th February 2019, asking this court to inter alia commit members of the County Assembly for contempt of court and to reinstate her to her former position. This court dealt with the prayer on contempt, but the issue of reinstatement was suspended owing to the fact that the issue substantially touched on the relief sought in this petition, and therefore rendering myself at that stage, and that at that interlocutory stage, would have had the undesired effect of premature decision on the petition itself. This court directed the parties to canvass or make representation in respect to that prayer at the hearing of this petition, so that the court could finally determine the matter. This petition was canvassed through written submission, and this is the petitioner's submissions. The petitioner states that she is a member of the County Assembly of Tharaka Nithi, having been elected in 2017 to represent Marimanti Ward, and is also the Deputy Speaker of the said County Assembly. She then reiterates that the fact leading up to the issue as stated in her petition. She submits that the issues for determination are whether the grounds for impeachment offended the Constitution, whether the motion for impeachment was untenable for reasons of being malicious, whether the grounds therein was sufficient to warrant a removal as Deputy Speaker, and whether the County Assembly has mandate responsibility of substance or removal of the holder of seat of a Deputy Speaker, and whether the petitioner ought to be granted the relief sought. The petitioner submits that the position of the Deputy Speaker is provided under Part 3, Section 16 of the County Assembly Standing Orders as adopted by the Assembly on April 2016, and that Section 16.5 of the Standing Orders provides that the procedure to remove a Deputy Speaker should be similar to those for the removal of the Speaker, which procedure is provided under Section 21 of the same Standing Orders. She submits that the Constitution of Kenya 2010 also safeguards against arbitrary exercise of authority and abuse of power by authorities, and also provides for equality, freedom of expression, and freedom from discrimination. They cite the Fair Administrative Action 2015 as providing a framework to regulate administrative actions. The petitioner submits that the motion to impeach her contravenes the spirit and fundamental provisions of the Constitution of Kenya 2010, and the ground of walking out of a meeting does not constitute serious reason to remove her as a speaker, as a Deputy Speaker. She states that she was never given an opportunity to say that she was heading to the washrooms, which was a distance away. She also submits that she was never cited for any conduct of using foul language against a colleague, and there is no record to that effect. Therefore, it is a view that her removal from office was malicious and intended to coerce her to submit to unlawful whims, as she had been vocal against corrupt practices in the county government. She stated that the ground used were not credible, and that the court has jurisdiction to decide this issue impartially and to grant her reliefs that are sought, or that the most appropriate or any appropriate relief in the interest of justice. The petitioner did not cite any case law to support her submissions. The respondent's case. The respondent on the 11th February filed a replying affidavit sworn by one Eric Thumbi. The affidavit was in response to both the petition and the application. Eric Thumbi identifies himself as a clerk to the Tharaka Nithi County Assembly. The respondent states that the motion and the petition are both in bad faith to stall the procedures and smooth running of the assembly. He also says that the petition is premature, as should await a ruling by the county assembly before going to court. They also state that Article 177 of the Constitution of Kenya only recognizes the office of the Speaker and does not create a post such as Deputy Speaker. And further that, Article 178 provides that the Speaker shall preside over proceedings of the County Assembly, and in absence of the Speaker, any other member elected by the County Assembly shall do so. It is their case that the substantive office of the Deputy Speaker does not exist in law, and therefore it is the mandate of the MCA or members of the County Assembly to remove the petitioner as they wish, because they have powers to do so. The respondent says that no constitutional right were infringed and the petitioner had no locus to institute this petition. The respondent also states that a conservatory order to restrain the introduction of a motion would have adverse effect on the day-to-day running of the Assembly and would open a floodgates to frivolous litigations. The respondent states that Section 9(4) of the County Government Act complements Article 178 of the Constitution of Kenya, and that the full understanding of the instruments of the law renders the status of the office of the Deputy Speaker untenable. The respondent's submissions. The respondent submits that the petition was based on a decision that had not been made and was therefore speculative. They reiterate the contents of their replying affidavit and state that there is no constitutional or statutory position of a Deputy Speaker of a County Assembly, which is the basis of their entire petition. They further submit that the procedure as per the standing order was followed. They further submit that the Deputy Speaker being elected by the Assembly can also be impeached by the same Assembly. They state that the petitioner was informed of the impeachment, was afforded an opportunity to defend herself, and that the vote was presided over by the Speaker, and the petitioner was hosted with the required 75% vote. They contend that the right to fair hearing is set out in the case of County Assembly and two others, versus Kisumu County Assembly, Service Board, and 7 others, which is a consolidated petition. The respondent also submits that the petitioner seeks to have a removal declared a nullity, and yet she has not adduced any evidence as to the process itself to show any impropriety. They bring to light the fact that the petitioner has even failed to attach the motion that was the impeachment motion itself. The respondent submits that as per the case of Anarita Karimu Njeru, which is a 1976 Kenya law report, the petitioner should have set out the case with a reasonable degree of precision on the provisions infringed, and therefore the petition, in their view, falls short of the threshold required. They have relied on the case of Mumo Matemu versus Trusted Society of Human Rights, Alliance, and 5 others, Civil Appeal number 290 of 2012, on the importance of having precise claims. The respondents submit that the issue in the petition are overtaken by events as she has already been impeached, and that application for reinstatement is misplaced as she has not even provided a next decision showing her impeachment has taken place. They also cite that affirmative action for gender is not a matter of law and does not form any subject in this petition. The respondent urges this court to exercise judicial restraint and refrain from interfering with the working of the County Assembly, legislative and their mandate. They urge this court to dismiss the petition with cost and insist that the petitioner has failed the substantive tests, analysis, and determination. This court has considered this petition and the response made. The main issues in this petition are basically 2, which are: whether the impeachment process initiated by and through the respondent against the petitioner infringed or violated the Constitution and our constitutional rights. 2, whether the petitioner should be reinstated. I'll begin with the first issue, which is whether the impeachment process violated the Constitution of Kenya or the petitioner's rights. The motion against the petition at the County Assembly was dated 4th February 2019. And this court knows that the said motion indeed gave 2 grounds for the removal of the petitioner from her position as Deputy Speaker. The grounds given are relieving the Assembly in protest during the committee's election meeting, and making unsubstantiated allegations against a fellow member of the Assembly using unparliamentary language, thus compromising the dignity of the Assembly. The petitioner's only evidence tendered in this application is the said motion. The petitioner could have done herself good by availing the copy of the standing order 631, County Assembly standing orders, for this court to determine whether the procedure to impeach her pursuant to the said order were followed. She has also failed to avail a copy of the County Assembly answered in order to impugn the reasons for her impeachment. This court finds that the petitioner has not clearly established a course of action in this petition, and this court's findings are based on the following grounds. The petitioner has faulted the County Assembly for moving to impeach her on grounds that which in our view do not warrant a removal. However, this court finds that because the doctrine of separation of powers, the body mandated to determine the merits and demerits of grounds of removal of a person from County Assembly is the County Assembly itself. The court cannot arrogate itself the power of the County Assembly. The petitioner has cited some grounds of defense to the allegations of her removal, including the innocuous reasons as to why she walked out when the selection committee was in session. But the power to entertain and determine the petitioner's defense certainly is the County Assembly of Tharaka Nithi, and not this court, since under the provisions of Article 185, Article 3, the County Assembly is empowered to exercise oversight role on all organs and bodies and the county government of Tharaka Nithi. This court finds that the petitioner's claim that the grounds for impeachment did not meet the threshold is incompetent, as it has not been properly placed before this court. Sorry, I'll take that again. He is incompetent because it has been improperly placed before this court instead of the County Assembly of Tharaka Nithi. The petitioner has not faulted the process of her impeachment or alleged that the County Assembly or the mover of the motion to impeach her overstepped his mandate or breached the cardinal principles of natural justice, to wit, rights to be heard or accorded an opportunity to defend herself. In the absence of questioning or challenging the process of her impeachment, it is hard for this court to intervene to save her, because the power of removal, just like the power to appoint, vests in the County Assembly. She has claimed that the County Assembly discriminated her on grounds of gender, but she has not given the particulars of the discrimination. And the fact that her intended replacement, in my view, may just be political reasons, and this court cannot jump into that arena for obvious reasons. In the absence of any hint of procedural impropriety in the impeachment proceedings on the part of the respondents, this court cannot be called upon to intervene in the impeachment proceedings, because it is within the mandate of the County Assembly to initiate impeachment proceedings of office bearers falling under their oversight roles. I agree with the respondent that a person seeking a constitutional relief against an administrative action taken against her by a statutory body must set out with a reasonable degree of precision what he or she complains about, the provisions say to be infringed, and the manner of the alleged infringement. In this matter, the petitioner has failed to pinpoint exactly the violation or the infringement, or how the infringement occurred, and mentioning in passing that that action was taken against her only on account that she is female, in my view, is insufficient and does not meet the threshold set out in the case of Anarita Karemu Njeru, which has been cited by the respondent. Whether the petitioner should be reinstated. The petitioner has asked this court to reinstate her because she was removed when there was a stay order from the court against her removal. It is true that on the 12th of February 2019, this court stayed the impending impeachment motion against the petitioner. The issue of service of the said order was hotly contested, and in the end, this court found no evidence or proof of service of the said order prior to the proceedings of the County Assembly of the impeachment on the 12th February 2019. The respondents therefore escaped the court's sanction because the petitioner failed to establish that they had deliberately and knowingly breached this court's order. Having made a finding that the respondents were not culpable for violation of the said order, this court directed the respondent not to install a replacement until this petition was determined, and both counsels in these petitions agreed to that arrangement. The respondents have not been faulted for going against that understanding. The question posed is whether this court should order that the petitioner be reinstated to her previous position. Before I delve into the aspects, perhaps it would suffice to have a clear perspective of the legal position of a Deputy Speaker of a County Assembly. It is not disputed that unlike the office of the County Assembly Speaker, the position of the Deputy Speaker County Assembly is precarious one, owing to the fact that the position is not a constitutional office. Article 177 and Article 178 of the Constitution of Kenya, 2010, only provides for the position of a County Assembly Speaker. The County Government Act 2012 also provides the office of the Speaker, County Assembly, and other offices like Leaders of County Assembly, which is under Section 10, and County Assembly Service Board under Section 12. It is apparent that the County Assembly rely on Section 14 of the County Government Act 2012 to provide in their standing orders establishment of the seat of Deputy Speaker, just like other various committees in the House. The office of the Deputy Speaker is not a constitutional office or substantive office with statutory procedures provided to fill or remove whoever serves in that office. That is why I find the position precarious and precarious in nature, because mostly the occupant does so at the whims of political exigencies of the day. In the case of Nathaniel Nganga Ruben, versus Speaker of Machakos County Assembly and another, the court found that there was no substantive role provided in law known as Deputy Speaker, and the position created for acting Speaker or Chair of committees was for procedural purposes only. The court, presided over by Nyamwea J, made the following useful observations, which I quote. In addition, the provisions of the standing orders relied on by the petitioner as indicated in the foregoing do not create any substantive office, and indeed indeed may vary from county assembly to county assembly as regards the procedures that will be followed as the assembly undertakes its legislative functions. It is noteworthy in this regard that the chairperson of committees is the member of the county assembly that the Machakos County Assembly has provided will deputize for the speaker in the proceedings in the county assembly as envisaged under Article 178 and Section 945 of the County Assembly Act. The county assemblies are in this regard at liberty and have powers under Section 14 to designate any member of the assembly to deputize for the speaker in their standing orders and name any member they prefer, including naming that member as deputy speaker or chairperson of the commissions. Likewise, they can provide for the appointment and removal of any such member in the standing orders. What is important is to note that the provisions do not create constitutionally recognized position of deputy speaker and are only limited to the specific procedures of a county assembly. As noted earlier, such procedures can indeed differ amongst different county assemblies. End of quote. It is quite apparent, therefore, going by the above observations, that owing to the fact that creation of that office is purely a discretional matter for the county assemblies, according to their respective standing orders providing for such offices, the issue of appointment and replacement of persons to occupy that office is best left to each county assembly because it falls within their purview. Courts should normally exercise judicial restraint in interfering with such affairs as held in the Supreme Court of Canada in the case of House of Commons versus Valid, where it was held as follows, and I quote, "Court should exercise restraint as regards parliamentary and county assembly proceedings which are closely and directly connected with the fulfillment by the assembly or its members of their functions as a legislative and deliberative body, including assembly's work in holding the government to account. The restraint by the courts to interfere with the workings of parliament and county assemblies on account of their mandate and privilege has also been expressed in various Kenyan judicial decisions, including the Court of Appeal in the case of Okwengu, GPM Karaoke, and Mohammed, Judge of Appeal, and also in the case of County Assembly of Embu, with respect to exercise of powers by the county assemblies in the removal of state officers. The petitioner, despite a last-ditch effort to persuade me to save her in the spirit of affirmative action, since, quote, she is the only female deputy speaker in this country, has failed to impugn the procedure of a removal, as I have already observed, and has also failed to establish basis for this court to intervene in the impeachment that was carried out by the County Assembly of Tharaka Nithi. This court finds that the County Assembly were within their powers and mandate to appoint or remove any person occupying that office. This court cannot be called upon to interfere with processes of a statutory body unless the same violates the Constitution of Kenya or a specific statute. The court's sole focus is the procedures followed and the law. In the end, this court finds no merit in this petition. The same is disallowed, but I shall not make any order as to cost. That is the decision of this court.